Oh, that customs excise exemption.
Yes. Item 1 to 6.
Disposed of, 7 disposed of. Seven disposed. Who did live? None appears for the parties on call for the ends of justice. Registry to list this matter again on 18 parine. 18/8/2025. 9, 10, 11 AK. 12 to kill. 12 नहीं हुआ. Mentionation नहीं हुआ.
Matter may be possible for the time being.
Time being.
13.
Who is appearing for the government here? You have your affidavit here. Who is for the government?
13.
Nobody. Mr. Soma, you are appearing for the government. There was a direction, there was an undertaking given that you will file an affidavit on behalf of the Deputy Commissioner. It's with regard to identification of a plot of land.
For time being, also.
Okay.
The draft is appearing in.
Okay.
14.
Yes.
13,
Where is the affidavit?
I have received the instruction, my lord.
Where is the affidavit?
Yesterday, last night, I received the instruction. 1 week, my lord. I'll file that.
Mr. N. Das, learned counsel for the respondent, for learned government advocate, appearing for the respondent number
2 and 5, my lord.
respondent number
2 and 5.
2 submits that the instructions in the matter has been received by him and the affidavit would be filed on or before 4/8/2025. Registry to list this matter again on 8/8/2025 along with this said affidavit. It's only on that affidavit we are waiting. Moment we get that, we can dispose of this matter.
The instructions says exactly what the, my lord, my resources department has filed the affidavit.
Fine, bring it.
No
we'll-
government, no private land has been taken. But
Taken.
land has been taken.
So his case is gone. Just clarify that
Yes,
we'll
yes.
finish it off. Yes, Mr. Sotri. Kabrstan,
My lord,
land.
after looking into the judgment of Justice Bisnoy and your lordship judgment on the basis of Salakuddin, only issue that I can place before your lordship, there was a dispute between two Kabrstan property.
That is different. That let them take care where they are doing it. You are a third party. You are a tenant,
And I'm
and
protected.
Mr. Chaudhary, the land is still a government land.
Well,
It is reserved for Kabrstan.
But Kabrstan committee is not being given any financial help by the government.
Forget it. That is for the Kabrstan. That is, there is a title suit pending. Let them finish it off there.
Gives me a protection for not to be evicted.
No.
That is
No.
there, madam. That is-
Where?
I'm talking
That
about-
has already been gone into by this court in the earlier round of
My lord,
litigation.
your lordship will find that title suit order, page 109.
Oh, I'm having it.
It is one of the suit between the tenants and the landlords, where at last but one paragraph,
That is why the beauty here is that they have got no jurisdiction in allotting this plot to you.
Well,
The government has never given you an allotment.
no, man. Government has never given me an.
Then
My only issue was that whether the government knowing fully well that there is a dispute.
where is that decision of the division bench wherein I was a party?
Salakuddin, my lord, is that your lordship, after relying on I have brought Salakuddin, your lordship has held that notice has to be issued to every persons who are there as encroachers. That was your lordship judgment
And notice was given to you.
my lord,
The
but-
committee
my lord,
construed the
one
matter.
issue that we have placed before the deputy commissioner, that the revenue authority, we approach the revenue authority where they have stated that there is a dispute and they have given a direction.
And page 162, that order
My lord.
is a very elaborate, there is
My
elaborate
lord, but
discussion.
only one thing, my lord, if your lordship can look into this page where the deputy commissioner himself has said, go and deposit rent in the civil court under the Urban Area Rent Control Act. That is there, my lord. I'm placing that page 147. Your lordship will find. My lord. The vernacular is in page 148 and at page 147 it was issued. Yeah,
Read the vernacular.
my lord.
Read the vernacular.
ইয়াৰ দ্বাৰা আপোনাক জনোৱা হয় যে গুৱাহাটী অৱস্থান সমিতি গঠনৰ বৈবত সম্পৰ্ক
কামৰূপ মহানগৰ
মহানগৰ উপযুক্ত কাৰ্যালয় অভিযোগ দাখিল হৈছে ইতিমধ্যে দুজনকৈ সমিতি বা সমিতি বুলি
বৈধ
দাবী
সমিতি।
কৰিছে মানে
got it.
কমিটি
আৰু এই
সম্পৰ্ক আন্দোলন গোচৰ ৰুজু হৈছে অৱস্থান অধীনত জমি থকা দোকান ঘৰ ইত্যাদি ভাড়া আদায়ৰ ক্ষেত্ৰত এখন সমিতিয়ে আপত্তি জনাইছে এখন পৰিস্থিতিত আৰবান এৰিয়া ৰেণ্ট কণ্ট্ৰলত অধীনত আপোনালোকক আদালতত জড়িতে ভাড়া দিবলৈ জনোৱা হয়। So it was a fact, and what is the finding of the impugn order?
Then come to page 158, the order of this court,
My lord.
and the 160, para 7, the conclusion.
Para 60, Being-
160, para 7.
para 7, the court finds it relevant to observe the power to be exercised of the revenue under is only permissible if the land is a government land. It is a government land. My lord, the petitioner had liberty to take the ground if the land under their occupation are not government land.
So this order attains finality.
My lord, and my lord,
This order you have not challenged anyway.
no, my lord, what I am to.
Then
this
you went
order-
before the,
This order gives that the privilege of the Salakuddin in para 5.
that is why, then they complied with Salakuddin,
My lord.
and then the order is at page 162.
160, where the findings are wrong. That is why, my lord, here one of the Kazakhstan committee are in supporting us that we want the rent.
They are non-entity, Mr. Chaudhary.
Hello.
They are non-entity. It's the government land, and the government is saying we have not given.
But my lord, your lordship may look into this because we are there for 50, 60 years. And my lord,
Immaterial.
my lord, here,
Kazakhstan, let it be there for what it is
my
there.
lord, but what they are going to do, my lord,
They
this,
can't do anything.
my lord, practical, my lord, because my house is near to meet, what will happen, my lord, they will do in between the fight between the two Kazakhstan committee, the old tenants will be removed and after 6 months, the new tenants will be inducted. That is the whole contention.
That we will have I'll provide for them. Don't worry.
My lord, here,
I will provide
my
for
lord,
them.
after 50, 60 years,
Yes, Mr. Dhar,
he is supporting me, my lord.
he is supporting. You are the first committee. You sit down. You have created the problem. You sit down now. Yes,
My lord, that,
we'll provide for that, Mr. Chaudhary.
my lord, but here, my lord, after 50, 60 years,
Can't help it.
my lord,
Can't help it. This Kabastan has to be for the Kabastan only. It's not a commercial area.
but my lord, they are
Let the
not
people who have gone there rest in peace.
this is only in the outskirt of the Kazakhstan, not
I
inside.
know that. I know that.
That is in the outskirt.
I
and
know
my lord,
that.
this
We all know that where it is.
and this shop, my lord, what your lordship will find that the impugn order, what they have said, that though we have seen that
That
we
is the final resting place. The people's that
My lord,
that has to
page-
be a resting place
my
only.
lord, page 162.
And I find the order of the district magistrate to be perfect. He has taken into consideration all possible grounds.
my lord, page 163.
Who is appearing for the present committee? The government, Mr. Who is appearing for the government? Deputy Commissioner. What is your take?
Rajiv Borpujari Lordship. he
Revenue.
gave All the instructions Lordship regarding this coming, yes.
Okay, we'll have it after some time. Let Mr. Borpujari be also.
Yes, come.
Oh, yes, Mr. Borpujari. Why are you disturbing them for last 50, 60 years? They are there.
That is only, sorry, my lord.
Huh?
Only
The
because
persons
this
who
was
have
because
gone,
of a
who
PI
does
matter.
not want a feed, but the persons who want a feed, you are disturbing. That is the allegation of Mr. Chaudhary.
And my lord, one thing, my lord, this is only because of a PIL of a political party who files a PIL saying that you want to disturb me and put some other new tenants, and my lord, that is through a PI.
That, Mr. Chaudhary, leave it to this court. We will ensure. And if that order is violated, you can always come up.
But my lord, here, my lord, after 60 years, suddenly all the family, 66, 70 shops, my lord, all at a time will be thrown out, my lord.
We are not convinced. I've gone through the whole thing, this orders of this court, and the last order, that was the nail in the coffin. Page 160.
62.
160.
But my lord, the findings at page 163, your lordship will find, where the representation, last part, one paragraph, whereas in the representation, the petitioner has mentioned in point 3 that a notice the deputy coroner recognized the shopkeeper applicant as tenant at the
Where? 160?
63, last part, one paragraph.
Whereas
Such and such. Hence, it is noteworthy to mention that.
then he goes on to discuss that,
Mal-
okay, you are the tenant, but you are not the
Can-
permissive occupant
Yeah,
in
my
view
lord,
of
then
the.
what will be the condition, whether they have issued a notice to the Kabastan committee that what illegality you have done. Now, what will be happen to the civil court? Civil court order is function. My lord,
Civil court order is qua the committee and you. Here the matter has gone beyond
but
that.
the committee has not been taken
Here
care
the
of. by government.
determination by at page 160 is, if you are on government land, then the consequences would be different. The
But what-
conclusion is
what
that this is government land still.
my lord,
there is no
government
allot-
given to the Kabastan
No,
committee.
Mister, that's the problem. There is no allotment here. It's only reserved for that purpose.
Reserve for
The government
they have
exercises
recommended to the
control.
Kabastan committee.
There is another case pertaining to the cemetery at Cheniguti Cemetery. Division bench has disposed of the matter.
My lord, your lordship may just take into consideration, let it remain part heard, but I will take the instruction, what will be the time they require to go, my lord. If you
That we will provide. Don't worry. Why keep it parted? I'll give you. Why? I'm giving you a reasonable time to go. But you tell me what would be the reasonable time.
no, that is what, my lord, because without instruction for 70%.
I'll have it after some time. You have a telephonic instruction. I can't read this brief again.
My lord, only thing, my lord, because if the whole.
I'll not hear Mr. Chaudhary, Mr. Borpujari now. You have that telephonic instruction.
My lord,
Mr. Mishra is here for a matter. We'll hear his matter, then come back to you.
and my lord, only thing, my lord, what I can find it out, my lord, if they have not issued to other Kabastan committee, they should have issued a notice to the Kabastan committee that you have done. something
Reserve
illegal.
that ground for the next round of litigation. Not accepted.
But my lord, after the eviction, there is no ground of litigation, my lord.
You take this instruction, reasonable time, come back and tell me. At 2, before 2. After Mr. Mishra's matter, we'll call your matter. Okay, Mr. Borpujari? Then I'll hear you.
Sir, I'm sorry, when the item number 13 I missed. So my presence will be taken by already when the other side has took time to file it.
Mr. P. Mohanto, Learned Counsel for non-appears in Likaba. P. Mohanto, Learned Counsel for the petition. Yes. Yes. Yes, Mr. Mishra. It's open to you now.
Short matter, my lord. Everything is.
For you, it's very short,
No,
but
no,
for
it's
me,
admitted in the, my lord, appellate order.
there is some.
Your lordship, Deputy Pathak is on Lake Singh.
We can't make a senior counsel wait like this. He should be here. Or he should make some alternative arrangement. How long will it take? Let Mr. Mishra continue. In the
please,
meantime,
my lord,
you take your notes.
I'll not take time, my lord. I'll just speak.
No, I want you to take time. I want you to be thorough in this so I understand it better. Yep, I'll do. Item number 16.
16.
Mr. Mishra, when you are here, please be detailed. So I can also appreciate the whole thing in a proper manner.
My lord,
Yes.
The petitioner before your lordship, MacLeod Russell India. My lord, it owns several gardens, and I'm told recently that total 60 garden now, although in the petition it is written somewhere 43 or something, but 60 garden, that's the instruction that they are, my lord, they own in the state of Assam, the length and breadth of state of Assam.
Owned and operated.
I know. Now, the subject garden is Bhutia Chang, my lord. Bhutia Chang Tea Garden.
Bhutia Changti Garden.
Tea garden. Now, these gardens, my lord, are in the charge of senior manager.
Hmm. Hmm.
The power supply to Bhutia Chang garden, my lord, is provided by APDCL
Hmm.
by an agreement dated 10/9/2009.
Annexure 1.
Annexure 1, which I'll not say to your lordship, that is not relevant for
Hmm.
this purpose. Only thing, my lord, the total connected load
Hmm.
is 938 kilowatt. And the contracted load is 609 kilowatt.
Okay.
Now, my lord, the authorized connected load of 938 kilowatt, my lord, is provides power to the factory, garden factory, and other gardens also,
The whole garden plus the factory.
plus the factory, by two transformer of 750 kVA each.
Of 750?
kVA each, kilo voltage ampere, it's if
Hmm.
I'm correct.
Hmm.
And this is an admitted position.
Hmm.
Your lordship, I'll just take your lordship through annexure 11
11.
at page 56. That is the appellate order. Relevant facts are mentioned, my lord, at page 59.
This is the appellate authority's order.
Appellate authority's order, which is under challenge before your lordship on a very limited ground. Now, my lord, I'll just show, my lord, the 11th line from the top. I'll come back to this
Page.
page 59. Just for this purpose, that 938 kilowatt,
Okay.
my lord, power is being distributed by using two transformer of 750 kVA each. If your lordship will take the 11th line from the top,
Hmm.
what it is. Further, the appellant vouched that the assessment malpractice of energy consumed was considered on full capacity of the said 750 kVA transformer, which is not acceptable as the total connected load of 938 kilowatt is shared equally by the two transformers. Now, what happens is, my lord, on 22nd of May 2013, the vigilance team of APDCL
Hmm.
inspects the garden, and they found that two cases of, they are using malpractice, I'll say two cases of theft of electricity.
In connection with these two transformers.
Yes. Now, my lord, unfortunately here, petitioner has tried to cooperate, because petitioner has specifically said that we do not condone such act of the senior manager. And senior manager was made to resign. He has resigned.
Hmm.
So we said, and therefore we have not taken lots of grounds that could have been taken. Now, here is the case where there is no inspection report.
That starting point.
Yes, there is no inspection report. I'm not going into that, I'm not challenging, but I'm saying that there was no inspection report. And therefore, what was discovered was, my lord, culled out from different, from FIR, from Caesar list by us. And now the same thing has been done by the appellate court. And I'll take your lordships through the appellate court's order at page 57, madam. Now, your lordship will see what was His lordship at page 57.
Hmm.
I'll read from the top. my lord.
Hmm.
22/5/2013, a vigilance team led by the Chief Vigilance Officer APDCL visited Bhutiachang Tea Estate and conducted an anti-power theft operation. During the course of operation, the vigilance team detected two malpractices through which the said tea authority committed theft of the electricity. The said consumer was provided electricity at 11 kVA through 11 kVA so-and-so Bhutiachang feeder originated from so-and-so Kachubil substation. The authorized connected load of 938 kilowatts was provided from consumers 2 into 750 kVA 11 by 4 kVA station through HT meter bearing so-and-so, so-and-so. But the vigilance, this is important, but the vigilance team during inspection found that while transformer number 1 was receiving power through 11 kVA metering unit, the transformer number 2 was connected directly bypassing 11 kV metering unit. Out of these two transformers,
One
one
proper,
was correct,
other one directly.
other was indirect,
So the transformer was bypassed there.
bypassed. Thus, the consumer committed malpractice as consumption of energy through the said transformer number 2 remained totally unrecorded. As a result of said malpractice of electricity, huge revenue loss was caused to the APDCL. This was the first case of malpractice detected by the vigilance team. So this is the first, that out of two transformer,
One,
transformer number 2 was bypassed. Now, this is the second malpractice. Further, it was stated by the vigilance team that surprised raid unearthed another malpractice in the tea authority had installed 11 kV infrastructure for a 315 kVA substation at pump house number 6 to draw power directly from nearby 11 kV feeder to run 40 horsepower motor to sprinkle water on the tea plantation during dry season. The said 350 kVA transformer was though not found at site, but was found in the tea factory. This is the fact. Then, of course, they're disconnected and all are mentioned. After detection, they have disconnected my power. Those things happen. Those, according to me, not very important.
then without that enquiry report, an assessment bill was prepared.
Yes. Now, thereafter,
Mm.
I may say, Milo, that so far as the second one is concerned, in fact, both. The calculation was made for a period of 12 months, which is required under section 126(5). But here, the tea garden, as your lordship will know, it runs on a seasonal basis. There are seasonal, on a given season, my lord, from April to October, 8 months.
Mm.
8 months. From April to November is the season of tea garden, when the consumptions are different, higher. Then from December to March, it's a lean period. And then sprinkling of water through 40 horsepower pump was for 4 months.
From December to March.
But they calculated for 12 months. So we, in our appeal, we had said that this is not correct. That was accepted. So we have no grievances insofar as the second point is concerned, that pump house thing is concerned.
They have taken care of
Okay,
it.
yeah. Now what
So they
remains
have
is,
reduced it to 4 months.
yes. Now what remains is the first one.
Hmm.
Now, in respect of first one,
Yes.
Now, and then they, as usual, they lost the first information report against the senior manager, they resigned. Then, my lord, a provisional assessment was made. And we deposited 50% of the provisional assessment and we filed the appeal. Now, the point urged, my lord, before the my lord, our arbitrator was that power was supplied by two transformers. And it is the case of the APDCL that only one transformer, that is transformer number 2, was compromised. But while making calculation, they have taken into consideration transformer number 1, in respect of which there is no
Allegation.
allegation. And our case is there, my lord, noted down by the learned arbitrator at page 57, which I just read out to your lordship. So, my lord, the cost of repetition, I'll say that our total case before the appellate authority is, look, it is your own case. It is the case of the APDCL that one transformer was. So why calculate for the second
So
one?
you mean to say that in this case, only your grievance is that whatever loss has occasion to the APDCL, it will be qua the transformer number 2.
Yes.
So whatever bills you prepare in that we are ready to pay.
Yes.
What is the finding finally given
Now,
by the?
finding your lordship will see, and its finding is based on speculation, if I may say so. At page 62, if you my lord. My lord, I'll take it straightway to page 62, fifth line from the bottom.
Bottom. Now go while going.
Now, while going through the fact, it came to my mind whether we can ignore the possibility of total bypass of authorized connected load of 938 kW intermittently from 11 kV network of the said so-and-so substation, or intermittent use of load from other 750 kVA transformer. This is not the case of the AP, my lord, the inspection team. So this is based on speculation, and on that basis, it was, my lord, rejected. And one last line is, my lord, the available record indicates that such possibility cannot be ruled out.
Ignored.
Now, therefore, on speculation, our, my lord, submission was rejected.
But here he has provided for both the instances. What were you said, but the second part is already taken care of.
No, that is pump house.
Pump house, because he's provided for the pump house also.
Pump house, because he says 4 months. Calculated for 4 months, because they had calculated well for 12 months.
Oh, now it's 4. This is how it has been resolved. So this is in your favor.
Yes, this has been taken care of. This is the only point, and then another one point is left, which is, of course, a statutory violation.
Mr. Can you just have a seat? I'll just go through it once. He also records that you accept the facts, but you are asking for a review in the manner indicated above, one, and that 4 months in the second instance.
That's the only melody. Otherwise, we have never disputed. We don't know. The manager was there, what he did.
Vicarious liability.
But here, let me use this opportunity to clarify one point.
Yes, sir.
Because often when I'm arguing, it is said that section 135 contains onerous responsibility upon the APDCL to prove the case, which is, my lord, not so in respect of compensation is concerned. Your lordship can have the 2003 Act, Electricity Act 2000.
Electricity Act 2003.
Can provide. It will be.
I've just come into this premises yesterday only. The books have not been. No, it's here. She has done it. Yes, section 130.
135.
Right.
Whoever dishonestly,
Hmm.
dishonestly has been defined under section 24 of the Indian. Dishonestly will defined as for causing wrongful loss to others and gain to himself.
Hmm.
That is called.
Hmm.
So the purpose is this: whoever dishonestly taps, makes, causes to be made any connections with overloop, overhead, underground or underwater lines or cable or service wire or service facilities of a licensee or supplier as the case may be, or tempers the meter installed or uses tempered meter current reversing transformer, loop connections or any other device or method used which interferes with accurate or proper registration, calibration, or metering of the electricity current or otherwise results in a manner whereby electricity is stolen or wasted, damage and destroyed an electric meter apparatus, equipment, or wire or causes or allowed any one of them so damaged or destroyed as to interfere with the proper or accurate metering of the electricity, or uses electricity through a tempered meter, or uses electricity for purpose other than for those, other than for which usages of electricity was authorized, so as to abstract, or consume or use electricity shall be punished with imprisonment which for a term which may extend to 3 years or with fine or both. And these punishments, if your lordship will see the provider, is based on quantum of energy stolen. 10 kilowatt, the punishment is different. More than 10 kilowatt, the punishment is severe. Now, whosoever, it doesn't say consumer.
Whoever.
Well, my lord, say company. A company will not go and steal. Sometimes the manager, what they do, as I'm told, of course, it's not in, I was instructed not to write. But the manager will do it, will tap. And they will charge the company for the diesel, saying that there was no light and we used the generators. So he is being profited from both sides. This is what I discovered, my lord, this. But I was instructed not to write, so it's out. Now, therefore, my lord, whoever does this shall be punished, and your lordship will know. Article 21 has to be followed. It has to be beyond reasonable doubt. If there is a doubt, he'll escape. Now, with that, whether the compensatory part also will escape? No. Because section 154, if my lord will come to. Section 54.
150.
154, I'm sorry. Yes. Now, this is under exclusive jurisdiction of the special court. The lordship will see 154. Notwithstanding anything contained in the Code of Criminal Procedure, every offence punishable under section 135 to 140 or section 150 shall be triable only by the special court within whose jurisdiction such offence has been committed. That exclusive jurisdiction. Now, my lord will come to 5. 5. I'll place 5 and 6, but before that, just below 6, if your lordship will see the explanation. Explanation, just below subsection 6. For the purpose of this section, civil liability means loss or damage incurred by the board or licensee or concerned person, as the case may be, due to commission of an offence referred to in section 135 to 140. So this is for compensation, and compensation would be, my lord, to the extent theft has been committed, based on the quantum. That, and it will be decided by the special court. Now I'll place 5. The special court shall determine the civil liability against a consumer or a person in terms of money for theft of energy, which shall not be less than an amount equivalent to 2 times of tariff rate applicable for a period of 12 months preceding the date of detection of theft of electricity, or exact period of theft determined, whichever is less. And the amount of civil liability shall be determined, recoverable as if it were a decree of the civil court. If your lordship has just seen the first paragraph, first line, the special court determines the civil liability against the consumer. So whether consumer, my lord, has done it or not, the civil liability will be on consumer, and he'll have to pay. Your lordship, you see, there is another word mentioned, or a person.
That's what is
Or a person denotes to a person who doesn't have any connection, but he has taken connection by hooking.
okay. This is not in relation to the consumer, but a person who is not a consumer,
Yeah.
but has tapped.
Yes.
Okay.
In Allahabad, my lord, they call it katia.
Katia.
They'll put that katia and then run AC. So this is for them.
These incidents are on a rise, even in this part of the country now.
My lord, if there is a judgment, I couldn't lay my hand, but I was told when I was in Allahabad for 2 years, I was told that the court has said that he has applied and you have not provided, therefore he is doing it.
A novel way found out.
Yes. So, my lord, but in this case, we are not going to any of these things, man. Any of these things. So the first point that I have urged before your lordship is the vigilance team of APDCL has found that only one transformer was compromised. Why include second transformer in calculation? That is transformer number 1. This is our submissions that spare that, leave that one. But then, my lord, appellate court says, well, speculatively, it cannot be ruled out. It cannot be that you are using it intermittently. So that, according to me, my humble submission, that is something which is required to be interfered with. Now, the another thing is, my lord, here also, initially, the assessing officer has assessed for 12 months,
That is with regard to both.
both. So one is gone.
Hmm.
This one also has been taken care of, but there has been some overlapping.
Hmm.
Because season is 8 months and off season is 4 months, so 12 months.
Hmm.
Here, my lord, while giving this brief to us in respect of this, what the appellate court did was, it says calculation total should be for 9 months, 22 days for seasonal period and 4 months for non-seasonal period. So that is against the statute provisions contained under subsection 5 of section. Because the maximum is 12 months, 12,
So they have gone beyond 12 months.
beyond 12.
By 1 month, 22 days.
13 months, 22
22
days. So 1 month, 22 days. If your lordship will see, 126.5.
One 26.5.
26, subsection 5. If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for entire periods during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection.
Here the period is not determined, so it will be 12 months
12.
prior to the vigilance visit.
From the date of 12 months, your lordship is correct. Now, I'll take your lordships through the relevant portion of where the period is given.
Hmm. Page?
Page 63, man. Eighth line from the top. Therefore, in my considered opinion, due to the said malpractice, the assessment of total energy consumed by the aforesaid seasonal industry as per guidelines in clause 5.A.4.4 of the Electricity Supply Code, regulation of AERC should be made for the first instance with total authorized connected load of 398 kilowatt for 9 months. That's seasonal, my lord. Now 9 months, he is reckoning, my lord, 9 months and 22 days. That is seasonal period with effect from April 2012 to 22/5/2013. So it comes to, my lord, 9 months and 22 days. And the assessment of energy consumed in off-season should be made considering 452 kVA maximum demand recorded during off-season, that is December to March 2013, as the demand is more than 40% of the authorized connected load. The assessment of total energy consumed thus evaluated as per clause so and so for the first instance of malpractice be adjusted with the energy bill already paid and paid by the appellant during the assessment period so and so to arrive at quantum of theft of electricity. That is. So now 13 months he cannot give. And see the adjustment. How the adjustment is made? We are paying, my lord, for one transformer. We never knew that we are paying for one. We thought we are paying for everything. So we have paid for one transformer number one, which is compromised. Now, whatever we have paid, first, they are making assessment on 100%, 938. Then there is a formula, my lord, which is given in 5.A.4.4 at page 136 of, I'll provide, my lord. Say. It will be difficult for him to read. I'll give. I'll call him. 5.A.4.4.
5.8.4.5.
Page 136, the last one. The page number is below.
4.4. Unmetered use of electricity.
Unmetered use of electricity. When a consumer indulges in the theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to its other right, will assess the quantum of electricity loss on the basis of assessed consumption of detected category as per table 6.2.1.1 and connected load for a period of 12 months prior to the date of detection, as your lordship has said, prior to that, and will be billed at the rate 2 times the existing tariff. So what we have paid, first they will put the penalty and then give deduction.
So you are again paying back for the first consumer
Yes.
twice.
Yes. My lord, so therefore, my case, my lord, is only this. The other points I have not challenged. I have not taken. Otherwise, my lord, in other cases, I have taken that when there is a theft of electricity, 126 has no application, which is now being heard and part heard before Justice Chaudhary, which is part heard, which I'm doing. So I'm not, nothing is challenged here because Bhutia, my lord, the MacLeod Russell didn't want to condone what has happened. And we condemn it. But there's obvious, according to us, this is an obvious mistake. On the basis of speculation, you cannot include the other transformer, which your own vigilance team found that it was working properly. It was connected to the metering unit, 11 kVA metering unit. And then so far as 13.5 months is concerned, that is against the statute. It cannot exceed more than 12 months, even under 5A.4.4 that I have read before your lordship, and to section 126.
26.
This is my submission, madam.
If I have understood you correctly,
Madam.
the total load, connected load was around 938
38.
kilowatt. And this was to be distributed in the garden through 2 transformers
Equally.
So 938 divided by 2, it will go along.
Madam.
So you were continuing. The inspection takes place.
Yes.
During the inspection, they find one transformer operating.
Yes.
No complaint.
Yes.
The other transformer was not there where it should have been.
Yes.
It was found kept inside your factory
This
premises.
was in respect of the T-guard.
Okay, this was not used. This was not being operated, but there was direct tapping from the line.
Yes.
Then the second incident that was found was there was a motor pump inside the campus, which was being used for sprinkling purposes during the lean season. But this was through direct tapping.
Yes, and the transformer was found inside.
Inside. That's what I said. It was found inside
Yes.
the premises, not where it should have been.
Yes.
So they say that these two malpractices, theft of electricity has taken place.
Yes.
So they go and determine the amount now you have to pay, which is twice the amount which normally tariff is to be
Yes.
paid. Then you deposit 50%, go up on appeal. Your case was that when there are two transformers, one is functional, you should have made provision for exclusion of that
Yes.
thing. And with regard to the second one, whatever you do, you
Yes.
do.
Yes.
But they, by applying it for twice and then deducting what you have paid, they have also taken into account the first one. With regard to the, and this was done for 12 months.
Correct.
And the second motor, they also said they did not go for the lean period, they went for the total period. Now the appellate authority, with regard to the first calculation, it said 13 months, 22 days. And with regard to the second one, they said 4 months. That whatever is there, you have no grievance. Your grievance is basically with regard to the transformers.
And
The billing of the
cannot be
transformer.
13.
No, the billing of the transformers per se, one, that it should be qua one of the transformer which was not operative, and it should be for a period of 12 months from 22/5, preceding 22/5/2013,
Divided between seasonal and non-seasonal.
non-seasonal period. Okay.
That's my case.
Yes, Mr.
But there were two instances of malpractice in this case. For coming to the formula, one was
Just for my understanding, let us put it like this. There are three instances. There are three instances. Two transformers and one power. Right? There are three setups there.
actually there are two instances. Your Lordship.
And that means you are also giving up the first one. That is proper.
Lordship will kindly have the FIR that will just specify what the two instances are.
Page
The relevant portion is at page number 30.
30.
These are the two instances.
Yes.
Yes, this is an FIR to the officer in charge of the Paneriya police station. What you will have the first instance is the bypass of the meter number so and so connected from so and so to so and so by means of tapping of the HT main line before CTP.
So this is the second transformer.
Yes. And the second instance of malpractice is unauthorized hooking to transformer number so and so from HT mains to the pump house. So those are the two instances. Now, as far as the first instance is concerned, there the meter has been bypassed. There was a meter. And the second is a direct hooking. So there is no recording of electricity whatsoever. Now, what the officer has, appellate authority has done is the first one, there is a there is a formula given. He has assessed it for 13 months, off season and peak season. So that 13 months, I'll address your lordship. But for the second one, he has again relied on the consumption in recorded in the transformer. That perhaps may not be permissible because there is a formula given in the supply. As a authority exercising his power under section 127, he is as bound by the supply code as we are, or for that matter, the consumer are.
You mean the appellate authority?
The appellate authority. Once that formula is given there, your lordship, he could not have, he has perhaps exceeded his jurisdiction. That is my submission. So I'll address your lordship on both the issues. Your lordship has the Electricity Act, your lordship, section 120.
But you will also have to address me on the issue raised by Mr. Mishra, that when there is no apparent, there is no malpractice found qua one of the transformers, and the other two, for my understanding, if I can put it in this way, other two were direct tappings.
Yes.
So this, what readings are reflected in the transformer A cannot
He
be,
has made an assumption, your lordship. That cannot be.
that
according to
cannot
me
be.
also.
So that has to be excluded, and the calculation has to be qua the second transformer wherein there was a bypassing of the meter and the motor.
Perhaps even because your lordship, as soon as we rely on the transformer, the element of, I mean, for want of a better word, arbitrariness to the entire system. Because nobody knows what the actual consumption was. They are just relying on the reading of the transformer.
No, the consumption which is there
Yes,
from the transformer A, that is recorded.
that is
That is
recorded.
not disputed. Now you have to assume the consumption which would have also come in through transformer 2.
Move this assumption, your lordship. There is a formula given in the supply code, so that this element of assumption is completely out of the picture. And the assessing officer, the appellate authority, has completely bypassed that form, so that there is no element of assumption involved.
But you have not challenged the order of the appellate authority.
No, in fact, your lordship, this order, we had filed the review. That was not allowed. That was what I was.
But thereafter you have not taken the process. So
But-
that order, as far as you are concerned, you have accepted it.
But since it is before your lordship,
How can I, in his petition,
I'm only saying,
Okay.
since it is before your lordship, it is my duty to point out that
Okay.
there was a formula, he has made a mistake.
okay,
This formula which he has applied,
is wrong.
perhaps it might be in our favor, it may be in his favor, but it has been wrongly done.
Okay, got it, Mr.
So since your lordship is exercising certiorari,
Mm.
so if it is completely perverse and against what the supply code says, then perhaps your lordship can cause interference.
Okay, do it. Go ahead.
If I may take your lordship to section 126 of the Electricity Act. What has happened, your lordship, this is otherwise a case of theft of electricity.
Hmm.
So regardless of the determination of the civil liability by the
Sure.
court under section 154, there are Supreme Court judgments which say that the provisions of section 126 to determine the charges payable for indulging in such theft of electricity.
And Mr. Mishra has not argued that this determination by you is wrong.
I'm also
He says you kindly go ahead and make it, but make it in this manner.
very. So if I may take your lordship to subsections 5 and 6 of section 126. If the assessing officer reaches the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period. Lordship will kindly see entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. So there are two possible scenarios, your lordship. One, that the period which can actually be ascertained might be more than 12 months. Then the petitioner will have to pay more than that, or it might be lesser. If it cannot be ascertained, then it will be taken at 12 months, regardless of what the actual period of usage. And secondly, your lordship, number 6 says, subsection 6 says, the assessment under this section shall be made at a rate equal to twice the tariff. Lordship will kindly take a note of this. Rate equal to twice the tariff applicable for the relevant category of services specified in subsection 5. So there are two elements, your lordship, the period and the tariff, which has to be twice. Prove this sense of assumption from the entire formula. There is a formula given from the entire process. There is a formula given under the supply code. These are the relevant provisions, your lordship. Into your lordship has the supply code, clause 5.8.4.4.
Yes, just place that. Huh.
When a consumer indulges in theft of electricity, the officer authorized in this behalf by the government may, without prejudice to its other right, will assess the quantum of electricity loss on the basis of assessed consumption of detected category as per table under 6.2.1.1 and connected load for a period of 12 months prior to the date of detection, and be billed at twice at the rate of 2 times of the existing tariff.
Hmm.
So there is no concept of any off-season or peak season, this formula. There is no concept. Now, the table at I beg your pardon, that table that is not before your lordship. As per the table at
Yes, table is there.
table can
Yeah,
It's here.
yes,
the page.
6 point.
these are page 1225, you know.
Yes.
Page 1225.
Table.
Lordship will have serial number 12.
Hmm. 200.
Page number 1226, serial number 12, yes, it is 200. So the estimated consumption, since lordship will see, this is only applicable for theft of electricity, not for unauthorized use. Why? Because if the meter is completely bypassed or if it is hooked, there is no way of calculating what is the actual use of electricity. So to remove that arbitrariness from the system, it has been said for this category, this will be the estimated consumption, monthly consumption. And in lordship will see this formula, where I'll take your lordship to where this concept of peak season or off season has come from in the mind of the appellate authority, but the formula which is there in the supply code, which is framed by the ARC under the powers granted to it under Electricity Act, there is no concept of off season, peak season. There is a formula given, and as per this formula, that calculation has to be made at twice the rate for 12 months in case of theft of electricity.
Now, just for my query. This is the load consumed by the,
Consumed.
but the connected load here is not 200 kV. It is 938 kV
938
kW.
No, that is the connected load. This is the consumption, your lordship will see.
So what is the
But-
basic consumption, normal consumption of this
Yes.
tree garden?
How this is that your lordship will find at page, how this was calculated at page number 36.
Of the paper?
This is what the calculation would have been as per the formula. This is our calculation before it went before the appellate authority.
Calculation by the assessing officer.
This is the thing. Lordship will see bypass load at factory 38 kW. So the SS units, this is the formula applied, detected load into 200. This is from the table per kilowatt. Now the bypass loaded factory was 638 kW into 200. That is from the table. So 127600. That is the number of units. So the units will be, your lordship, the number.
Now, what is this bypass load at factory 638 kilowatts?
This is the kilowatt is the lordship connected load. And because the connected load is the actual number of appliances found connected. But
Okay.
that does not calculate.
Then why are you adding 200 units to it?
Because there is because consumers are not built on the connected load. They are built on consumption.
So why is this connected load multiplied by the
Yes.
consumed load?
Why that happens, your lordship, is connected load is the actual number of appliances connected. Now, there are two components of charge and the energy charge. The fixed charge is on the basis of their category. And energy charge is on the
Consumption.
So how that is calculated, or when the meter is there is no difficulty. It is the amount of appliances used per hour. So what we see as a unit in a meter is the total amount of electricity consumed by the consumer in 1 hour. kW per hour. kWh is what we colloquially call a unit, your lordship. So here your lordship will see 200 units. The detected load of the consumer at what was detected was 638 kilowatt, your lordship. So it will be
Okay, 200 units is per kilowatt.
per kilowatt. So that is what will be assumed to be their consumption. So that has to be multiplied by the connected load to arrive at their consumption. So this 127600 is their consumption units. expressed in kVA or kWh.
If we
Thereafter,
can come back to 6.2.11.
yes, Your Lordship. Per kilowatt per month, Your Lordship.
Per kilowatt per month. So it is, the total given is 200.
200 per kilowatt.
Maximum estimated, it's written estimated.
200.
Yes.
200.
Yes.
200 per kilowatt per month.
No, no, there is nothing
No.
there.
No, no,
If it- no,
calculation.
Mr. Just for my
Yes,
understanding,
sir.
estimated consumption
Yes, Your Lordship.
per kilowatt
Yes, Your Lordship.
per month.
Yes. So it's,
So it is said to be, what is this 200?
that is a K, that 200 is kVA, Your Lordship. So that it will be 200, the detected load was 628, Your Lordship has seen. That was expressed in kilowatt. 200 into detected load per month. That is the figure.
But
to
here
arrive
it
at
is
the
only
units.
kilowatt per month, per kilowatt per month, per month.
This 200, Your Lordship, it is a figure which is expressed in kVA, that is 200 units.
But it's not specified here.
Because Your Lordship, consumption is recorded, it says what is the estimated consumption. The unit of measuring consumption, Your Lordship, is kVA. And kW is the unit of potential capacity of a system to consume electricity. Those are two different concepts, Your Lordship.
I'll just clarify one thing.
Hmm.
My lord, kW, kilowatt, if it is divided by 0.85, it becomes kVA.
Hmm.
And if kVA is multiplied by 0.85, then it became kW.
Kilowatt.
This is unit only.
So this per kW per month, whether this can be read to be 200 kVA.
That is 200 kVA.
It is not there. my lord.
Because Your Lordship will see
Nothing, we
that
can't
200 is
read
the
anything
estimated
which is
consumption.
not there.
Estimated consumption. Consumption is recorded in kVA. It is cannot be recorded in kW. So to arrive at the consumption, it has to be multiplied by the connected load found at
So
every mine.
the 638
Yes.
is the connected load
Connected
for
load.
two transformers.
Yes.
Yes.
That is, yes. As
That two transformer,
Yes.
one transformer, you will have to presume that there is nothing. So how can this be done? You do this exercise for one of the transformers and for the tea garden, that sprinkling motor.
was the connected load, Your Lordship. Back to the formula.
No, connected load, what was consumed in one of the meters, it's already there.
Yes.
So deduct that.
But the law does not permit us to exclude the transformer.
No, you'll have to, because the law may not have envisaged the situation in that connection.
Once
The
formula is
law
there,
will have to apply where the cause a malpractice has occasion. Apply it there.
there is a malpractice here. And it
Got it.
says that it will be calculated. Lordship will kindly come to the formula at 5.8.4. If it was permissible under the formula, then you can exclude one of the transformers.
No. This is for the meter. Unmetered use of electricity. There was a meter in that transformer also. It's not a case that there is two transformers and one meter. Each transformer has its own meters. So you are bypassing, the petitioner is bypassing one of the meters.
It is bypass only one of the
One of the
one
meters.
of the-
So your calculation would be qua that meter in terms of 5A. Why go into all those things? Limit it to that, finish it off.
8.8.4.4 says that it has to be calculated on the basis of connected load. It does not say that connected load, it has to be Lordship will come to the definition of connected load. The act also.
No.
defines connected load.
You come here. When a consumer indulges in theft of electricity,
Yes, 5.8.4.4.
5.8.4.4.
Yes.
The officer authorized in this behalf, so and so may or its other will assess the quantum of energy loss
Energy loss.
on the assessed consumption of the detected category as per table so and so and the connected load for a period of 12 months prior to the date of detection and will be billed at the rate 2 times of the existing tariff. Now, here the unmetered bill, unmetered consumption is qua one of the what do you call that, transformers. If that be so, you will have to apportion the connected load to that also.
Why, what my submission would be, Your Lordship, that would be the
Because why I'm telling you, he has committed a malafide. But with regard to the main, transformer A, he has paid his dues. He has paid his dues. Say it was 100 rupees. Now, when the transformer B, please don't mind, this is my way of understanding things. If transformer B comes in, there is another 100 rupees which he has bypassed. He has not paid. Now, he has to pay 200, twice the rate. 200 rupees. Now, if you take the whole thing, it will be 100 plus 100, 200. Now, he'll be paying you 400. That means you are charging him double for the bona fide use of electricity by transformer A.
that interpretation perhaps would come if the petitioner has.
Forget it. That's a practical.
Itself defines
There
what connected load
has
is.
to be, Mr. Pathak, you are to be compensated for the actual loss suffered by you.
Lordship,
not
can we see the
beyond-
definition of connected load for one?
Yes.
Because what the officer has done, he has gone by the definition that is provided.
Okay. Where is that?
Lordship will find at page number 1182.
118 of?
Please, of the book that your Lordship.
This one.
On the other one, the supply code.
Okay, supply code.
Yes, sir.
118.
1189.
1189.
This connected load has been defined in the.
Means the aggregate of the manufacturer's rated capacity of all in
energy consuming devices connected with the distribution license. So this definition includes both transformers. Your Lord. It does not limit it to 1 meter.
No, each transformer will not be serving the same appliance.
What you will kindly see, connected load means the manufacturer's rated capacities of all energy consuming devices connected with the distribution licensee mains.
Fine. Mains are through two different approaches.
There might be two separate transformers. The mains will be the same, Your Lordship. Mains will refer to the APDCL energy
Then why are you having 2 meters? Why are you not having 1 meter?
because the petitioner perhaps he requires 2 meters.
No, every transformer is a meter transformer.
No, transformer is transformer is for.
There cannot be a
bringing down
situation.
the voltage of the.
The transformer also has a meter
Not really sure.
because transformer has a meter.
Yes, that is a meter which is with the AP. Yes, with the APDC.
Because you have not brought here any other meter other than the transformer meter.
For the purpose of consumption.
Huh.
Yes, what that the appellate authority has done.
Here also, because you have only gone by the presumption that this would be you have assumed that this is the load and you have multiplied it by 200.
During the transformer, Your Lordship, if the transformer is, for example, serving only the petitioner, for example, then the connected load in the transformer would show.
You come to the FIR,
Fire. Yes.
page 34.
Yes, Your Lordship.
Bypass of meter number so and so
Yes, sir.
because of tapping.
Yes, sir.
So here there is a bypass of a meter and there is a specified meter.
Yes, sir.
That is why you are referring to the provisions of your assessing officer has referred to 5A44
Four.
unmetered use of electricity. So it's that meter.
That meter.
So why you have already have a reading with regard to the consumed electricity for the past 12 months
Yes.
with regard to transformer A, right?
Yes, sir.
So that has to be excluded. Your loss that has occasioned has to be calculated in the manner known to law with regard to transformer B and the power.
Yes, there is this one thing I will throw light to the entire document which Your Lordship has at page number 36
Of
which is
the
for- of the writ petition.
36.
First calculation which was done by us prior to the matter going for the
Hmm.
There, if I may just be permitted to take an instruction whether the 638 kilowatt, your lordship, that is only regarding this first meter, or does it include the other
Fine.
transformer as well?
Fine, you can have that
Very
instruction.
good. Lordship will have it at
Mr.
2
We'll not keep Mr. waiting for the whole day.
Okay.
Sorry. That transformer has to be also understood that the connected load is distributed through
Yes.
two.
That's-
Otherwise, there is no point in having
Yes.
two transformers.
Yes, what this 638 kilowatt, what is stated to be the bypass load at the factory,
Is the total.
if that is only regarding this 1 meter
Uh,
and one transformer, then there is. this
then
statement would
it's
be
a
correct.
different,
I
different.
just get a clarification.
Then
on
it's a
that.
different thing
Yes.
altogether, because his total allotted lot is 938. If you can demonstrate that it is 638 for that
Yes, sir.
and 300 for the other one.
Otherwise, I understand what is falling from. I still stand by my submission that connected load, it mandates us to connect the entire.
Because we can only compensate you to the extent of your loss. To the extent of the loss suffered by you, twice that rate. Twice that rate. But how you come into that picture, you can't have an arbitrary nature, subject to what you finally
Yes.
say. You can't have an arbitrary calculation wherein the total thing consumed, paid is also again evaluated and brought within the
Yes,
malpractice.
if it has been metered and already paid.
Paid.
Then perhaps it would, I'll be fair, your lordship, that cannot be.
Transformer number 1 is already metered and paid.
Yes.
So that consumption has to be
So if
excluded.
This 638 kilowatt is for the transformer, which is meant, only transformer which is meant
Bypass.
with the FIR. That is.
Because you are referring to,
89,
subject to
52.
correction from the parties, you are referring to 5.4. This calculation is made on the basis of 5A44.
The one I am referring to.
And that can be in BICA with regard to unmetered use of electricity.
That is what-
FIR says that qua that transformer, the electricity meter was bypassed. Got it. Give me a photocopy. I don't want, sir, this is such very personal book. I don't want him to lose this. No, it's okay. Just give me the relevant portions, the definitions and all. You have that instruction when it will be convenient to you, sir. Any date.
Need it. You see, because
Can it be after 11th of October?
Subject to.
Subject
but
to-
sir,
That you
But
tell him,
Yeah.
let him appreciate that and then give me the date.
my lord, I have absolutely no.
No, we don't want to
Can-
trouble you on a
Yeah, my lord.
date.
Your lordship can take it up on 12th. My lord.
12th, done. Only this, it's boiled down to this.
Let it
It may be nonsensical what I've asked, but that is what has come to my mind.
Rather, I remember Mr. Pathak, my lord, I call him, he's a child, he's doing very well. But my lord, one child had a bet and he went and told his mother that I had a bet with so-and-so. So what is the bet? He said, no, he said the milk is white. I said it is black. So you will lose. Oh, when I will lose, I will not ever accept that milk is white. So I'll never lose. Mr. Pathak will never accept.
No. What he is trying to project is
Yes.
that why go into this controversies? We have a formula of our own. 200 we take and we apply. But now that you have argued that qua the meter 1, there cannot be any malpractice alleged. So that has to be taken out from the
Your lordship has
Consul-
seen the appellate order.
order. Okay,
It is mentioned.
okay.
And another one, as he said that we should have challenged the supply code. But there is a recent decision of the Supreme Court in Kerala, that Kerala electricity. There, my lord, under section 50 of the Act,
Hmm.
they amended 126, my lord.
Kerala government.
Yes,
Hmm.
Act.
Hmm.
126 stands amended.
Hmm.
Unauthorized loads, they say that if unauthorized load is within the premises, then it will not be considered unauthorized. But it is outside, yes.
Hmm.
So So Supreme Court says, how can you? So the argument from the, my lord, authority was that they should have challenged this supply court. He said, no, they have challenged or not. It's the duty of the court to keep you in check, and we will keep you in check. You
But
are seated delegated legislation.
Mr. Kejriwal had placed this submission in the division bench. I think you were also there. That this meter being outside the premises.
That is different. That he will not be liable. There is a provision, my lord,
decision.
in the regulation 13.3.
13.3.
That is there.
So, but if it is inside,
Yes.
that there will be nothing else, detection you will pay, that provision is
But
not there.
that decision I'll bring where my lord says that, like he says that there is a formula and we have not challenged the formula. So whether one is okay or not,
That I'm not accepting.
then Supreme Court said,
But
no, you cannot.
You just get this instruction whether it is 638 qua the transformer where malpractice is found or both. We will decide.
Then perhaps may help me also, Your Lordship.
Which one?
I'll place that issue.
Because there, the amendment that was done, Your Lordship, that was not in tune with section 1. This one is.
No, here there is no question of amendment. It's the application of the provisions, whether you have applied it properly, whether the actual loss, what is the underlying factor? The loss suffered by you has to be compensated in the manner. That is twice the number. Now, how you arrive at that loss has to be in facts, determined in each and every facts in a particular manner.
Yes.
If there is theft qua one of the transformers, and one of the transformers you have no dispute because I find nothing is there, then the electricity consumed therein, it will be for a particular area. We'll call it for a particular area in the appliances used therein have to be excluded.
Yes.
Now,
They
when
are
you
limited in-
you take that whole thing, you bring in this appliances also and say this is 638, then there will be a reverse prejudice coming.
The only reason why I stopped today was, Your Lordship, the terminology used in the statement is bypass load.
Hmm.
Now, if they have done a load assessment or load survey on the date of the inspection, which is.
But they will know
They will-
how this
Yes,
is
how they-
apportioned.
So if how they arrived at this figure of 630 kilowatt at page number 36, that is perhaps the crux of the issue.
I think if your lordship will see annexure 1, page 24, that agreement, it is from here. It is from here, my lord. In the agreement, your lordship will see the sanction load in 760.
760, yes.
Then connected load is 938. Then contract demand is
717.
17. So it's
Off season.
60
And your Mr. that thing, that this 12 months cannot be further subdivided. As has to be understood in this term of this agreement. You are here, you are having two contract loads.
Two contract loads. The contract load, perhaps because this is beneficial for the petitioner. Once he has indulged in theft of electricity, and there are penal provisions under the act which does not.
We will see that. I got what you want to say.
Peak season.
I got it.
Then perhaps this cannot be.
I got it. I got it. Since once he has committed a offense, he cannot take the benefit of the benefit.
Well, the offense is yet to be proved. What they are doing is, my lord, I'll just, my lord,
Okay,
2 minutes. What they are doing is, your lordship will kindly take section 135. 135, subsection 1A. 1A. Lordship, without prejudice to the provision of this act, a licensee or a supplier, as the case may be, may, upon detection of such theft of electricity, immediately disconnect the supply. So they disconnect. Third proviso, your lordship will see, provided further that such officer of the provided also that the licensee or supplier, as the case may be, on deposit of payment of assessed amount of electricity charges in accordance with the provision of this act, shall, without prejudice to the obligation to lodge the complaint as referred in second proviso to this clause, restore the supply within 48 hours of such deposit. So they are making an assessment only for the purpose of restoration of a power which was disconnected on detection of theft. It is, my lord, subject matter of the other one. Otherwise, there is no provision in 50 for making this assessment. So they say there is 126. If your lordship will see, 2005, my lord, order. 2005 order. Yes. This is at page 132, my lord. If we have
130.
same book, or and if your lordship has a new one, it has which page?
132.
Order say 2005.
First one.
Removal of difficulties order.
Yes. Now there is a statutory provision under section 183(1) that if there is any difficulty in implementation of the act, the central government will have power to pass orders removing that difficulty. So they have done it. And I'll come straight to 2. Inclusion of measure of control for theft of electricity supply code. The electricity supply code as is specified in the state commission under section 50 of the act shall include the following: method of assessment of electric charges payable in case of theft of electricity pending adjudication by the appropriate court. So this is for the purpose of third proviso of 135.
135. Special code.
Yes, it is not a compensatory sort of a thing which is provided under subsection 5 and 6 of 154 of the act.
So you are trying to, your submission is that compensatory, whatever it is,
Yes.
it can be only in 135, 5 and 6.
Yes.
That is special.
Special court.
Civil liability.
Yes. Here,
Okay. But
yeah.
this is for my, no, this is not for
This-
your consumption. This is for my consumption.
You kindly have such a.
Because he is not arguing that matter.
I only hope, my lord, one such case comes before your lordship. Because, my lord, we on this side, we are not at all concerned where it will go. We want a correct law to be laid down.
Thanks for the
See,
expectation you have.
I have. My lord, he is talking of one judgment which says 126. Their explanation is read as part of the section. What do I say, my lord? Explanation is for different purpose altogether. It's only for that purpose.
Judgment has been passed by the apex court.
2 judges bench.
It has taken note of this. And then they arrived at a
Yes,
finding. Whether it can just be lightly
Some-
disregarded.
We'll consider that when we have to cross that bridge.
Yes. We'll
I can
cross
perhaps
the bridge
satisfy
when
your
it
lordship on
comes.
that.
But this one, kindly appreciate the arguments which Mr. Mishra has advanced and I'll put it, the queries that I have raised.
Very well.
If that can be that apportionment of load, how we can find out a way wherein the interest of the APDCL is protected and the consumer is also not put to a difficulty beyond what he is to be put to.
He should not be priced for something which is already.
He has already
Yes,
paid.
Yes.
That-
Understand what is called.
I may be wrong. Mr. Mishra may be wrong. You clarify.
Very well.
You are the best judge. You clarify. But this is the tentative view we have.
Very well.
But Mr. D.K. Mishra, Learned Senior Counsel, assisted by Mr. A. Sandalya, Learned Counsel, appearing for the petitioner, and Mr. K.P. Patak, Learned Standing Counsel, APDCL. Full stop. Parties have been heard at length. However, the hearing remains inconclusive. Full stop. A registry to list this matter again on 12/8/2024-25 as a part heard matter. Thank you. Some insight into the act now. Because I am also getting new things after coming here.
Supplementary list 24.
File today, my lord. It's not on your phone.
Get that? You have got a copy?
Yes, just now.
Okay. Mr. MJ, heard Mr. MJ Borua, learned counsel for the petition. Mr. Learned Government Advocate has submitted that the affidavit in terms of the order dated 14/7/2025 passed by this court in the present proceeding has been filed today. Accordingly, however, the same is not on record. Registry to trace and tag the said affidavit and trace and tag the said affidavit along with the present records, along with the records of this case, and list this matter again on 18 of Pishatia 21.
Published.
Standing 12.
Mr. Soikia, Mr. For 12. Not possible. Twice we have done it.
One leg.
I know that.
And its senior counsel is X.
Your thing is whether that what do you call that non-performance report, Mr. Chaudhary, Mr. Muslim, whether it can be elevated to the status of a blacklisting.
Doesn't contain the
Reasons.
Not only that, non-consideration of the reply that we have filed. In one line they have disposed of.
So what is the effect of this non-performance report?
Basically, this amounts to blacklisting.
For how many years?
So long as it remains.
Till the completion of the work underway. Project work.
So
he has been terminated.
Hmm.
He is executing the.
Now, this termination that was there,
my lord.
was it put to challenge before this court?
Yes, the repetition was there. Repetition has been dismissed.
Did I appear in that matter?
No.
NHIDC?
Huh? Yes. Anything.
Where is that order? You have that order here?
Oh.
I had appeared. Mr. Talda, did I appear in this matter? The earlier termination of this.
Yes.
The termination was put to challenge.
And that petition is 2957 45. Your lordship was
I was there. 29?
2945.
You're sure I was there?
Yes, for NSI decision.
I remember this case
Justice Pathak.
before Justice Pathak. 29?
45.
2945. 2945 Marisokshan. Of 2022.
Of 2022.
And then those I searched the file, but I could not get any order wherein 2945. Justice Pathak got list what
2945.
Yes.
22. Asiluni. Huh?
Remotely connected otherwise.
Others connected matters.
Remotely connected.
Still, why? Because I've already argued the matter against you
Right, against me.
against you in that case.
That
Raised it to list this matter before any other bench without me. Mr. Soikia, you will have to wait for a 1 day. Because that I remember this was a contested matter. Mr. SSD and you,
Yes.
SSD was some matters it
Good that-
remains.
Good that your lordship remembers.
Yesterday when I was reading this, otherwise TK engineering have nothing
Otherwise,
to do.
otherwise it's our duty to point out, but I am not.
No, but TK engineering have
Yes,
nothing to
yes,
do.
sir.
But with regard to the same cancellation, which has now led to this order,
No, that's an independent. It has-
I know that, but it's connected to that. So why I argued against him in that, so I should not.
This is not. I also did not appear at that time, so I am not.
You need not. Mr.
SSD
Day
was
had
there,
appeared.
Yes.
Some
Yes, man, it is there.
Asu. You were there or Miss Bora was there? You were there. Hmm. The parties have urgency in the matter accordingly. Registry to list this matter before the appropriate bench within a period of a week from today. Within a period of week from today.
So let there be fixed date so that
I can't do it because I'm
Oh,
not
yes,
doing it.
yes,
So
yes.
within a week from today, you approach the registry.
let it be 2 weeks. Second week, possibly all of us will travel.
Suitcases, two weeks.
The other,
Packing of suitcases.
no, the other thing is.
No, I said packing of the suitcases. Not you take it otherwise.
Yeah. Otherwise, on 10th, it's a Sunday.
Sunday that we
Ah.
have that. So after
12th,
that,
12th also they have.
we have.
Ah.
So you'll also be there.
Yes. I would like to be there.
You should be. All should be there.
Yes, ma'am. Obliged.
Yes, Mr. Monto.
My lord, regarding my lord, establishment of a stone crusher machine in a residential area. The 3 persons, my lord, they are staying nearby and
So first, the PCB made an examination, verified,
Hello.
found that it is not satisfying. They have
we don't.
revoked the consent to operate. Then the additional district magistrate, he submits a report.
My lord.
And on the basis of that report, this the consent to operate is again given and the query is operating now.
My lord.
That's your
That is the
case.
case.
Now, where is that report of the additional district magistrate? Subsequent report basing on which the
Yes.
thing was revived.
Revive, my lord.
Ah.
But before that, my lord, your lordship kindly wants to look into the, my lord, page 26, my lord.
26. That is the complaint.
My lord, that is the complaint and there is an inquiry and then now you pay page 36, my lord. We don't, 36.
Hmm.
Withdraw consent to page 36, my lord.
Hmm.
Consent to establish the order dated so and so. We have been withdrawn and the
Proximity to residential area does sound generated from the
Proximity
question so and so likely to so.
sound generation from the crash during the operation of likely to cause the health hazard. So that was the finding while withdrawing.
Now, what is
Yes. To be a lordship correct, my lord, that now again they, my lord, is 36 as well. Page 44, your lordship kindness. Now page
44?
44. In spite of the withdrawal, they also, my lord, running, my lord,
They're running.
running.
Then there was a
44.
thing from the district magistrate,
My lord.
subdivisional magistrate.
My lord.
Then for 52,
No, your lordship kindly see once, my lord, page 44, my lord.
yes. Then he was directed immediate closure.
Yes, he was directed.
And that is on the basis of the report of the direction of the pollution control.
My lord.
52.
Now, my lord, your lordship kindly see 52, yes.
Now, this is what I don't understand. If the pollution control board had said that no, because of these aspects, we are not allowing you to operate because they are the person.
And how the, my lord?
How? Where is
distinguished it?
this report?
Yes, that will, my lord, that will find, your lordship will find.
That report I want to see.
On the basis of the public hearing, my lord, that was that.
How can that be?
Yes.
A report of D. Singh, ACS, so and so forwarded white communication dated 25/8/2020.
That is, my lord, in the affidavit, my lord, your lordship will find.
Hmm.
Affidavit filed by respondent number 3. Sorry, my respondent number, affidavit filed by respondent 7, 8, and 9.
7, 8, and 9. 6, 7, 8, and 9.
6, 7, 8.
Dated 13/3.
Dated 13/3/2019.
15.
15 page 10, my lord.
Public hearing in connection with setting up of so and so. Okay, this is the report.
This is the report, my lord. Your lordship kindly, very interesting. My lord, last pair, I feel lordship, my lord. Is
Yesterday, I was not being able to lay my hands on this
and that is also
because it was like a communication, so I did not. Okay, Mr. Ajrekar. After my visit, from there, or as for opinion of the public, you want to
my lord.
gather in the venue and so on.
As for opinion of the public who gathered here at the venue on that time fixed for hearing, it was seen that a large number of public wanted to Amguri Khat Stone Kasa unit to be operated with proper system to arrest the air, sound pollution. According to the Dinesh Soikia, who would shift the unit from present location if he entire expenditure incurred by the setting up the unit was refunded. Therefore, as a majority of the local public supported the proposed stone casser unit, the Amguri Khat stone casser unit should be allowed to operate in the present location with argumentation of the proper system of arrest of air sound pollution till such time that initial investment is.
Who is appearing for the pollution control board? Can you just ask somebody to get hold of him?
So they cannot acting on that, my lord.
Yes, Mr. Ajrekar, you are for the strong casser.
Initially, I was appearing for the respondent 10. In the meantime, he died, my lord.
Then now the 10.1,
I have
10.2.
instruction to appear on behalf of the
Okay,
wife
fine.
and his son.
Same thing.
My
Same
lord.
thing.
Same thing, my lord,
Final.
before going to the marriage, my lord, may I point out the provision of the air prevention and control pollution.
No, we are not on that. Examining the feasibility and the compliance as required under the provisions of the Water Act, Air Act, whatever it is.
My lord.
The Pollution Control Board had come to a conclusion that permitting this unit to operate would be harmful to the interest of the residents of the area, as well as which would mean that it's in violation of the provisions of the Act, Air Act, Water Act, everything. You had, even in spite of that cancellation of your consent to operate, you had continued to operate.
No, my lord.
Yes,
Well,
there is an order.
Well,
There is
I'll
a,
come to
be
that.
that as it may, what has come out. Then the subdivisional officer, jurisdictional, issues an order that asking you to stop. Now, all of a sudden, the district magistrate, he comes up with the additional district magistrate comes up with a report. And a perusal of that report says there is no scientific basis to that. There is no scientific basis. It's only says that the people who had gathered there had said they want this to be. How can that be? Yes, Mr. Borua. You have a scientific way of examining things, or you may go by the public opinion? Your board
Board has the laboratory.
laboratory. And if you once take a decision that this a unit stone crusher, operation of that is injurious to the health of everyone residing nearby, you have done it on the basis of some materials you have collected. Now, on the basis of a public opinion that to permit the crusher to operate till he earns a profit therein, and you permit on that basis to again give him a consent to operate, what is this?
But in that regard, may I submit? I applies for the everything was redone. But
But it's not here, it's here.
that documents are not before.
Then that we don't know.
I have instruction to appear on behalf of the wife. Recently, they're implemented. Documents which are.
We are only concerned with as of the date
Yes.
when the order was passed. Subsequently, what you do, what you don't know. Because on the basis of this report at page 133, running page, everything was reopened. Or the consent of operation was again revalidated. That cannot be done. Yes, Mr. Barua.
Before that, may I point out.
That's only your case.
Apart from that, my lord, there is a report from the deputy commissioner also. It is within the, my lord, residential area, and my house is only 15 meter, my lord.
And somebody is staying near the boundary wall also.
My lord,
There is a report.
There is a affidavit filed by the deputy commissioner, and in residential area, as per the rules, my lord, it is not permitted, my lord. That is also one thing.
Before going to the
It may be a situation like this. When he started operation, there was no residence. Subsequently, the area became populated.
My lord.
So today,
Even then, it will be not done, my lord. Because
That
access,
is-
my lord.
no, that is the finding of the pollution control board.
My
also.
lord.
Yes, Mr. Barua.
May kindly have a look of section 31.
We'll see. We'll see. What does it say?
There is a appellate provision.
Forget appellate provision.
Appellate-
When an order is palpably illegal, why should we
that illegal-
require the? That is my jurisdiction.
My lord,
You
that's-
can raise your point. I'll decide. I come to page 40, Mr. Barua. Mr. Barua seems to be blank today. What happened?
I missed the case and
Okay. Normally, Mr. Barua is not blank. That's why we asked.
I learned friend.
Where is that cancellation, Mr. Monto? Cancellation of the consent to operate?
That is page 40, my lord.
40.
44, my lord. Probably 40. No, sorry, page
No,
36.
36. Yes,
Page 36.
Mr. Barua.
Yes.
36. So this is your conclusion, right? Then come to page 40. On finding that he was still running, you directed him to shift it from that place, right? Then the subdivisional magistrate, page 44, directed him to close it down. These are all a consequence of your decision at page 36. Now you come to page 52 and justify this. The report is at page 133, running page. If the deputy commissioner is to take a decision, what is the use of a pollution board for specialized matters like this? And you want the report? Take the report at page 133. That is the affidavit filed by 6789, your own affidavit. Got it? Mr. Monto, he seems to be a bit missing today because we'll consider it.
Can it be fixed tomorrow?
Yes, we'll consider it. So this is the only issue. Show me that after you have taken a decision basing on the rules, you can change that basing on a report which is not without any scientific basis by the magistrate on the consent of the peoples in the area, public at large, you can change your decision and permit the crusher to be operated. Just show me that. If that be so, we may not require pollution control board in such matters. The deputy commissioner is enough. Because you are a scientific, your assumptions are made on scientific basis. Everything.
Stone crushers and everything that we give the consent, we renew it from year to year. And subsequently, we also go through that fact that while renewing, they adhere to all the conditions that are set up in the consent to.
But
operate.
here we are only concerned with the order under challenge, 8/6/2014. That is on the basis of a report from the district magistrate. After page 36 order, wherein you said you had, on the basis of materials in your possession, come to a conclusion that, see, this operation is harmful. So thereafter, your interest is the public at large. Somebody coming and saying, and a report without a scientific basis, however you accept. This is the limited question you want me. If you satisfy me, we'll ask Mr. Monto to continue to suffer what is there, because that is law. If not, we'll ask Mr. Hazarika to shift it somewhere else.
That is subsequently will done, but will done. That I mean, subsequently will done. But that consent will not do, my lord. They cannot go by consent, my lord.
Consent and all will have
Because
to be
in that public
in the
meeting-
light of the public interest.
Because the petitioner, in my respective submission, petitioner has not.
If that is an apparent illegality, page 40, 8/6/2014, will the acquiescence of the petitioner render validity to that order? What is bad at law is bad at law.
After submission.
Well, that I'm just opening my mind, that's all.
My lord, can it be day after tomorrow? Tomorrow, my lord, I have a.
No, day after tomorrow, we can't, I can't even look at her for that date. Full.
Second half, my lord.
No, full. We'll have it on, কোন তারিখে পারি এটা 12 নিদিবা খালি পিছত দিয়া 14
My lord.
Thursday 14. Any problem, tell me. 14. First, Mr. As agreed to by the Lanark Council for the parties, registered to list this matter again on 14/8/2025 for admission hearing. You get this clarification. Maybe you don't have the file today, we are not troubling you. Mr. Talukdar, the records were directed to be produced. Has it come?
And copy of the receipt.
No. This is asked by this court. Say the first LAC had allowed their application.
Then subsequently.
So cancellation, we know, we see from that record that is there. But why? The LAC admittedly does not have a power of review. If reviewed, why was it reviewed?
In detail.
Who is the custodian of this?
Ownership Deputy Commissioner.
Huh?
Earlier it was SDS
sir.
civil.
Huh.
Now it is under District Commission.
District Commission.
Created district.
District Commissioner, South Salmara, Mankachar. Mr. Talda, you will have to find out a way because there is already an order.
Yes.
And
Yes,
rightly
yes.
so, because it's not discernible as to why. If there is a genuine reason, fine. We are not with Mr. Khan. But if it's just for the fun of it and to give that land to somebody else, then we'll have to come in. Mr. B.J. Talukdar, Learned Senior Counsel, appearing for you are appearing for all the respondents.
Except private respondent lordship.
Respond number 1 to 5. has prayed, prayed that the records as called for by this court, widely ordered dated 12/6/2025, is yet to be received by him, and he submits that he be given further 2 weeks' time to get the said records. Also, on the prayer made by Mr. Learned Senior Counsel, appearing for the respondents number 1 to 5, registered to list this matter again on 28/208/2025. Also, the Deputy Commissioner, District Commissioner, South Salmara Mankacha shall invariably place on record, shall invariably punish to Mr. B.J. Talukdar, Senior Counsel, the records as called for by this court, wide order dated 12/6/2025. Also, the District Commissioner shall also furnish particulars to the petition to Mr. B.J. Talukdar, Learned Senior Counsel, appearing for the respondents number 1 to 5, the reasons as to why the LAC in its subsequent meeting held on 6/2016 had cancelled the allotment made in favor of the petitioner in its earlier meeting held on 23/11/2015. So, the reasons to be now assigned have to be shown to be existing in the records of the matter. Mr. J. Hussain, Z. Hussain, Learned Jahangir Hussain, Learned Jahangir from J also it will be going. You are Z. You are the Z Hussain, Learned Counsel for the respondent number 6 is present. So, Mr. Khan, let it come.
Yes, Lordship. No.
20? 20. 2 not possible.
I'm ready with the case. I'll take Lordship more than 5 minutes in for this case. They can take the records and thereafter they can, Lordship 2017.
We'll hear it together. Don't worry. I'm giving it. We'll hear it together. I don't want this part. It's a great problem for me. A prayer is made on behalf of Mr. S.C. Cal, Learned Counsel, Learned Standing Counsel, CGST, for an accommodation in the matter today, as he is presently on legs in connection with another matter. Full stop. Accordingly, registry to list this matter again on next week. Ki pari? Nori. Pishor hafta? 14/8. 12/8. 12 to 12/8/2025. I fixed few matters. You will be in the line on that. But get both come together, because I know it's not very much.
It will take hardly 5 minutes, Lordship.
Then we'll have.
Law that has to be, Lordship.
Fine.
On facts.
For you, nothing. For this side, it may take some time.
Lordship. No joke.
Yes, Mr. Kumar. Finally, what do you say? Compensation. You admit that an illegality was done. We are not interfering with that lady's appointment at this late stage. But this man has also to be compensated. How much?
We have already.
You want to argue on that point? Argue.
Already concluded the.
So how much?
On the point of compensation, my lord, I have one judgment. Lordship, can you preface this, my lord?
What does it say?
Here, my lord, the matter was, the court said, my lord, when there's a delay in considering the application, my lord, so compensation was given in lieu of, my lord, compensation appointment.
Vidya Prasad.
Yes.
5 lakhs. That was the amount I had in my mind. Subject to what Mr. Kumar will say. What is your age today?
Around. 27 in 2000, my lord. 22, 30.
So some business, something he can do. Mr. Kumar, anything more? Forget that. Just nothing is there. No, there is nothing there. Only for delay, Supreme Court 141 power, it has said, we'll consider. We'll have to lay down reasons for that. We can't pass an order like we don't have the power. Supreme Court for doing complete justice can pass orders. We don't have that. We'll have to give reasons. So we'll give reasons and we'll dispose of. We are not interfering with the appointment of the private respondent, but vested interest only because of that page wherein the SLC has applied 2 yardsticks.
One yardsticks, his application has already been expired.
And what about the lady? Lady is also expired. Ladies, you considered the case of the lady.
At a time of consideration, yes.
That
Both the
only,
applications
that
are-
both the applications gone. Both the applications gone. That's the only point I have. How can you have 2 yardstick for the similarly situated persons? You can't.
But reason behind your lordship, kindly have a look into my second affidavit.
What is that?
During the while his affidavit was still in force, there was no vacancy.
Fine,
There was no vacancy.
fine. But
So-
on the day when you admit that both the applications were considered
They-
on the same day?
Basic foundation is that his case could not be considered because of want of vacancy. If it is so, your lordship, he has no vested interest.
But the case was considered on the same day? His case was not rejected on the ground that there was no vacancy? No, positive discrimination of a negativity done by the SLSC. His case was rejected on the ground that
Otherwise, also his case, his is by delay in lesser, your lordship.
okay.
In the year 19, your lordship, decision was
If
taken
it
by the
was not
SLC.
for that
If-
finding,
if
Mr.
it was
Kumar,
in 22 year lordship.
Mr. Kumar, if it was not for that decision of the SLC, I would have dismissed this case by following Devabroto Tiwari. We'll consider your second affidavit, don't worry.
We have also relied upon some
Where? You have placed on rescission on Devabroto Tiwari, Tridip Kumar Dingal. Anything more? These two. Heard Mr. M.R. Adhikari, learned counsel for the petitioner. Also heard Mr. K. Kumar, learned additional advocate general, assisted by P. Thapa, learned counsel appearing for the state respondent. Also, hearing concluded, raised to list this matter again on 19/9 delivery as an 19/8/2025 for delivery of ours.
Right.
Mr. Kumar, we'll go through it once and then come to a conclusion. Yeah.
I have talked to one of the person. There are around 70 families are there. Some widows are there, who children and others. On Friday, they are going for a meeting to have a consensus. Let it be on Monday. They will have a meeting and they will place it on Monday. They'll ostensibly keep it parted also, but that only that opportunity may be given because nobody can, all the families cannot meet at a time. One cannot give a consent.
We'll give you 1 month time
For what, Malad?
for shifting.
No, Malad, because
2 months, ma'am, at the outset.
Malad, at least that opportunity may be given. So all the widows and the families are there, Malad. They are running. Give at least a meeting, meeting opportunity by them, my lord. On Friday, they will meet, my lord, because
Okay. On the prayer of Mr. P.K. Roy Chaudhary, Lana Council for the petition.
Friday, and they're.
Will not give. We are not give. I said reasonable. I only wanted them to have a bona fide thing.
Express your lordship's mind.
After bona fide thing that, okay, we will shift within 2 months or 3 months. That would be the maximum. Mr. No, that we'll see. Mr. P.K. Roy Chaudhary, Lana Council for the petitioner submits that he be granted a week's time to complete his instructions in the matter and place the same before this court. Full stop. The Learned Council, Learned State Council appearing, Mr. H. Sharma, Learned State Council appearing, Government Advocate, Learned Government Advocate appearing for the state respondents have submitted that the petitioners who are illegal encroachers on, admittedly on government land, have to shift out of the place at the earliest. So, the said aspect of the matter would be considered on the next date of listing. Also, raised it to list this matter again on. We are putting it on 11. Next week would be a bit tight. 11/8/2025. Also, it is provided that no further adjournment shall be granted in the matter to either of the parties. Also, raised 11/8 for further hearing. Go ahead.
the interim order to continue.
Interim order, if any, to continue till the next date of listing.
There was for regarding that, for shifting, that maybe.
No, I'm not putting it deliberately. If there, I don't want him to make an argument tomorrow that it's 6 months. I've given him an opportunity to have a bona fide prayer before this court. Till 3 months.
They are waiting to file an affidavit, and they take, yesterday on one case, your lordship found, now they want to throw us, for 9 years, they have taken some extraneous consideration in a visual land, they are not throwing those person. They are in requirement of fund. Yesterday it came out before your lordship.
Because that.
They are pick and
No,
choose.
no, no, no.
There is
No, no.
admitted fact of pick and choose.
No, no, therein, Mr. Roy Chaudhary was very adamant that these people should be thrown out immediately.
Because all illegal.
Same Mr. Roy Chaudhary today is saying that have some sympathy.
Hello.
Have some sympathy
Hello.
for my clients.
That
So
your
it is,
lordship
it is,
more experienced
no,
in
no.
this, my lord.
It is, Mr. Roy Chaudhary, it's just the change of
My lord.
position as an advocate. We are bound to do that.
My lord. But
You are bound to do that because you are pushed or funneled, or the energy is coming through a particular source. And that source guides what you say. Same thing.
Lordship, regarding that, I have not put any date regarding that shifting.
No,
Your
no, no.
lordship viewed that it may be 2 months, 3 months.
That is my thing.
Yes, Lord.
Human consideration,
Yes.
we'll give them. But I want Mr. Chaudhary's clients to make a bona fide prayer before this court. If they come up and say 1 year, then we will go on merits
Lord.
and immediate eviction.
oblige.
Yeah.
22.
Yes.
Lordship, the present petition is against the constitutional order.
Oh, this case is not, you'll have to file a revision against the order of the district judge. Yes. Get hold of somebody from the forest department. This is against a order of the
Appellate
authority district judge. So it will be a revision before this court. It cannot be a writ petition 226, 227.
They have raised this issue before the last 2 occasions they have raised this issue.
Then what did the court say?
Court said that as the district judge, as a statutory authority, has acted, so he is not a civil court. So
Okay.
that issue
Okay, we'll have to consider that issue then.
Yes, Lordship. Lordship, order passed by the
Your name?
D. Superior.
D. Sutia, heard Mr. D. Sutia, Lana Council for the petitioner. None appears for the respondents on call. For the ends of justice, registered to list this matter again on 20/08/2025 for hearing.
Obliged.
Yes. Illegal construction. Yes, madam.
Appearing for petitioner.
Hmm.
We have filed a affidavit in reply, but it is the record yet, so
When did you file?
today it's the date may please be.
Okay, we'll have it along with that. The Learning Council, Miss
Intimony Sharma.
Huh?
J.M. Sharma.
Ms. James Sharma, Learning Council for the petitioner submits that an affidavit in reply has been filed today on behalf of the petitioner against the affidavit filed by the respondent number 5. However, the same is not on record. Registry to list this matter again after 2 weeks along with the affidavit in reply stated to have been filed by the petitioner today. Also, 2 weeks. Yes.
Please, Lordship, I have gone through the record that day, my lord.
Hmm.
But record says that, my lord, on the basis of, my lord, some of the villagers' statement, my lord, nearby and village, the committee has come to the conclusion, and there is against also. Some villager is saying against, some villager is saying that he's belong to. Only because of that, they have newly started to identify themselves, that village, they are belong to SA. Prior to that, they have no one was, as per the census report, my lord, no one lives in that village SC community, my lord. The only thing is that, my lord.
But this is a report of the state levels
But that is.
Caste scrutiny committee.
That is under silence because of that, my lord, the constitution of the, my lord, that state level scrutiny committee as per not guideline of Matri Patil, my lord.
But there is a notification to that effect by the state.
That is in 2018, my lord.
This was of?
This was of 2014, my lord,
Okay.
13, my lord. So that earlier there is notification. As there is no notification as per the Matri Patil case, my lord, they have to follow the direction as reflected in the para 11 of the, my lord, Matri
So
Patil.
at best, if we even interfere with the decision of the state level committee,
My lord.
now you having submitted that the decision was not based on any material,
My lord.
we can only remand back the matter to the state level
My lord.
scrutiny committee for a fresh
My
consideration.
lord, that notification, my lord, this is, my lord, this is a notification, my lord.
Yes, who is appearing for the
On
respondent
the
number
basis
7?
of Madhuri Patil, let them.
What do you say? You are no longer the chairman now.
Yes, how did they all the list of 1950 of his grant?
You have also given some land document also.
No, they could not connect, my lord. They have provided the land document, my lord. There is Koiborto, Das, and Talukdar, my lord. They could not link up. They have to link up that Horomon Koiborto is the Horomon Das. Horomon Das is the respondent father, and he is the son of the death. They could not link up. And that whatever document they have in the file affidavit, they are showing and they have occupied government land, my lord. That has been shown. Where is that land, my lord? If that is the 2023-24, I think, 2023-4 documents, my lord, is to be believed, my lord.
What is the name of the respondent number 7?
Prosenjit Talukdar, my lord.
Prosenjit Talukdar.
His father is, my lord,
Honiram Talukdar.
Dhoniram. Dhoniram is a son of Hormohan, my lord, Das.
Koiborto.
Hormohan Das, bringing record Koiborto.
Koiborto.
They have to link up the Koiborto and Das. Das to Talukdar, my lord. There is a government notification 2019, my lord. This is amended also, my lord, that when the different title is used, when issuing them a caste certificate in case of SC and SC, care should be taken, my lord. I have annexed in the additional affidavit. My lord, she may direct also to read, my lord, according to the notification 18, my lord. Because they have to, there is a vigilance, my lord. There is a vigilance committee, my lord.
Now,
They have, as per this notification, and Madhuri Patil also, my lord. Paragraph.
not reported, but earlier it was not.
So without vigilance, how can this
Who
officer
had made that
inquire,
inquiry?
my lord?
That inquiry was made by?
Made by the, my lord, they have, lordship may come to the, my lord. Lordship may come to page 41 of the repetition annexure 9, my lord. There is no record of constitution, only the direction, my lord, that. Who constitute the, my lord, that level scrutiny committee? There is no indication. Only this with reference to the above, I direct to inform you that a meeting of the state level scrutiny committee.
Madhuri Patel had laid down that the scrutiny committee, both 94 and 97 judgment.
Mile.
97, there was some variation.
Five.
But five?
Five, earlier it was 3 miles.
3. So they'll have to constitute one, even if there is no notification, if there is a requirement, will in terms of that only.
And secondly, my lord, the affidavit, he is swearing, my lord, I am belong to. Affidavit is his declaration, my lord. Where is the proof? And one, my lord, one Goswami, my lord, that villager, he said that, my lord, in the report also there, that this is not, if it is the SC village, my lord, we never go for
Now, if
solemnization.
you come to page 52,
My lord,
this is a verification directed by the chairman to the director,
my lord,
but they are the members of that committee.
my lord.
They are
Yeah.
the members of that state level scrutiny committee. Director WPTC. If you come back to that constitution,
My lord. This is
You will
the
find-
constitution, my lord.
no, that body or
Body
that
will-
letter directing forming of the,
But this is a, my lord, they have committee, back an inquiry, have a form a committee, my lord.
I got it. Now, if you can come to that letter you just showed me, wherein the committee was constituted,
That page
state
41,
level scrutiny,
page 41.
40. No. This one.
My lord,
Here, if you find the meeting
my lord. Will be held, my lord.
will be held. So these the three members
So
of the
including
committee.
The chairman will be 4
Fine. Be that as it may. These are the 3 members.
members, my lord.
Now, if you come to the page 52,
My lord.
the spot verification was to be done by the 3 members.
3 members, my lord.
Okay. Now, where is the records? Just find the enquiry report. Who has submitted the enquiry report?
My lord, the 3 officers, my lord.
These 3 only.
3 officers mentioned in the book. And they are also decision-making authority, my lord. They will inquire, they are the decision-making, but inquiry by a vigilance officer, my lord, as per Madhuri Patel.
Mr. Das, what is your submission on the constitution, whether it is in tune with Madhuri Patel? Now, this enquiry we are not worried, but whether the committee was constituted in terms of, I know the members therein, whether it is in term of Madhuri Patel. But I don't find the reasoning to be very. Okay. Mr. This is basically your argument. Just give me a small written note. When can you give me? Monday? So Das, you can also give me I don't want to take this records with me. You can just Xerox the relevant pages along with an index. You can just give me a small note. And the respond number, you also, if you want to give me a written note, please give me a written argument. Monday. What deal on a council for the parties at length?
My plan would be, my lord, either to my lord quash or go for fresh, my lord, because not done affirmatively.
We are keeping options open.
Fine.
Just give it, we'll take a call. The Learning Council for the parties are at liberty to bring on record their written arguments on or before. We'll give you some more time. On or before 30/7/2025. Raised it to list this matter again on Kundinapari 14/8/2025 for delivery of orders. You just give me that before so that I
By
can
which date, my lord?
by 30 or 31. Or you do one thing, you can give it to me by 4/8. By 4/8 Koridia. 4/8/2025. If I'll to rack it over, I'll lay at a home move detail. 4/8 and 14/8 I'll deliver.
My lord. Highly
Hello,
appreciate.
sir. Thank you.